People versus Bay.
Good afternoon, Your Honors, and may it please the Court, Kayla Hardesty, Cortland County Public Defender's Office, for the appellant Michael Bay. I am requesting 5 minutes rebuttal.
Yes.
Thank you. Certificate of compliance in name only will not shield the people from the application of the speedy trial statutes where discovery is incomplete and no exception applies to excuse the non-disclosure or permit the people to be deemed ready despite the missing material.
Counsel, can I for a per se rule? Are you asking for a per se rule? If something is not given, that certificate is illusory, the only remedy is dismissal?
No. So the people have the obligation to exercise due diligence, make reasonable inquiries, and disclose all known information and material subject to discovery. Once that's done, they file their certificate of compliance. That would be a proper certificate of compliance under those circumstances.
Even if they find something later?
It depends. If they find something later, as long as they've exercised the due diligence and reasonable inquiries and that can be demonstrated, something that is found later would not necessarily invalidate a later or previous certificate of compliance.
So what would the process in your view be at that point? So certificate of readiness is filed, say 10 days, 20 days go by, people find something else, should have been disclosed, no doubt. They come into court or they send a letter and they say, we found this additional document. What's the process that you think should happen at that point?
So at that point, and they've already filed their original certificate.
Sorry, yes.
At that point, they would file a supplementary certificate of compliance, and this is actually an amendment from 2022 regarding supplemental certificates. At that point, after their supplemental certificate is filed, the court would have to make an assessment to make sure that they had exercised due diligence from the outset to determine the propriety of that original certificate.
So who gets charged for that intervening time from original to supplemental would depend on the inquiry into the good faith of the original filing?
The due diligence and the reasonable inquiries, yes. And if it's found that the original certificate was not proper based on that assessment of the due diligence and reasonable inquiries, then the people's statement of readiness would have been illusory.
And the court would have to engage in a process of examining whether, in fact, that due diligence occurred if there was a challenge.
Yes, exactly. And that's right in CPL 3035. And in this case, there was an inquiry made by the trial level judge. However, the inquiry was insufficient to determine the due diligence and the reasonable inquiries.
Why was it insufficient?
It wasn't sufficiently probing of any due diligence or reasonable inquiries. In this case, the trial judge asked simply, has disclosure been reasonably met? The inquiry should be a meaningful assessment of the people's due diligence and reasonable inquiries. It should be open-ended questions.
So an actual inquiry as to what was or wasn't done?
Yes, that's correct. And the defense attorney, if discovery is missing and they're aware of it at that time, should make a record of that so that the court can make a proper assessment as to the people's readiness.
And what stage is that? Is that at the first juncture where a judge is looking to see whether or not to accept the people's certificate of compliance, or is that done at the second juncture when they try to file a supplemental, or at both? Both.
It would be both. Certainly from the outset when the original statement of readiness is filed, it should happen then. And then, since the amendment to the supplemental certificate of compliance section now says that the propriety of the original should be assessed based on...
So in this case, when originally they said they filed their original certificate and the judge said, there's no DIR here and there's no 911, what should have happened at that juncture?
So what should have happened is the judge should have inquired as to how the people know that there's no domestic incident report. Have they reached out to the police and asked about it, since it is a statutorily mandated item of discovery in family offenses? So it should have been a more probing inquiry into the people as opposed to just taking their word for it that it doesn't exist.
If at that juncture, and I know this is not what we have on the record, but at that juncture, the prosecutor had said, I reached out, and it looks to us like it was a walk-in for the following reasons, and so there's no 911 call. And then later, and then filed the certificate later on, discovered that in fact that was incorrect. Is that the sort of inquiry that might be sufficient, where there's a basis provided for the assertion?
Yes, certainly the people should be giving more information as to why they believe it would be a walk-in. So as you just said, Your Honor, that would be the detail that we'd be looking for in order to make that determination.
And what would happen if there was a subsequent discovery by the people of that item, which they've now accounted for with a reasonable excuse? What's the secondary inquiry when they try and submit a new certificate of compliance post-disclosure?
So it would be a more in-depth inquiry, and I guess a
Like a why didn't you find this the first time kind
right,
of
and
inquiry?
how did this come up now when previously you said that you spoke with the officer who indicated that it was actually a walk-in and not a 911 call? So just a more detailed inquiry into that.
And is that a per se, like, because that, is there such thing as a good excuse and a bad excuse in that context? Or having given a acceptable answer to the court the first time, which turned out not to be true, are you just sort of out of luck now, if you're the prosecutor?
As long as the prosecutor can demonstrate their due diligence and reasonable inquiries, and it's sufficient to the court, that would be sufficient to not invalidate their prior certificate. So
Presumably, that'll have to be sorted out on a case-by-case basis because
Correct.
the circumstances will differ.
correct.
So the 2022 amendment doesn't apply to this case, is that right?
That's right.
So is the result any different here?
I don't think it would have been, since the original inquiry wasn't sufficiently probing regardless, so it's unlikely that it would have happened in that, had it been in effect.
Let's say a judge, I know it's not this hypothetical, but a judge makes that determination. They come in, she looks at it, okay, I accept this as a good faith filing. What would be the standard of review for that? So if we saw it, you appealed it, but we had that, again, it's not this case. I understand I'm not speaking about this case, but there is this determination on the record, there's an inquiry, judge makes a determination, good faith filing. What would we review that for?
So the review would be as to the due diligence and reasonable inquiry.
But would it be an abuse of discretion on the part of the judge?
That could potentially, yes. Absent a valid statutorily defined exception, a statement of CPL 3030 readiness that's preceded by an improper certificate of compliance is illusory and would not stop the speedy trial clock. Because the people in this case did not file a proper certificate of compliance, their statement of readiness was illusory, making the case subject to dismissal on speedy trial grounds.
And the exception that you're referring to is that if something was lost or destroyed?
Yeah, so there's several exceptions. The people have argued that the defense is requesting a perfect prosecutor standard. That's just not the case, and that's not what the statute says. The statute has exceptions for items that are lost or destroyed, has exceptions for if the people are seeking a protective order, and also special circumstances. And those are things that they would have to go to the court
But the
for and
statute
request.
also says reasonable inquiry, right? And so is it your view that a reasonable inquiry might still be one in which there is a mistake, even if it doesn't fall within one of those exceptions?
Yes, that's possible. As long as the reasonable inquiries are made, I think that the statute is flexible in from the standpoint that not necessarily every single little inquiry is always going to get every little item.
So reasonable doesn't mean perfect.
Correct, and the statute doesn't,
Use
like I
that word.
said, ask for a perfect prosecutor standard.
So can the prosecutor rely on representations from, let's say, the police department that it was responsible for an arrest, for an investigation? They rely on those statements?
So, to a certain degree, because the people are deemed to be in the possession of all items possessed by the police, and 245.55 delineates an entire section called flow of information that the prosecutor has the burden of establishing with the police. And one of them is that they can request an entire file from the police, and the police would have to turn that over.
But let's say the mistake is with the police. They missed something and it just didn't turn it over. And they find it a month later. Does that fall on the shoulders of the prosecutor?
It does.
What else would the prosecutor have done?
So the prosecution should always be making...
They turn over the entire file, that was your example, something not in there. It's not something that, looking at the file, one would think obviously is missing. Why should that fall on the prosecutor?
Because they're deemed to be in the possession of all items in the possession of the police, and not having that fall...
Sure, I understand that, but here's the file that's been sent over, right? I mean, you're talking about the constructive possession that's recognized in the statute versus now I've got possession of the file that should have contained this material, this document perhaps, or some other material. And the police are informing me, that's it, we don't have anything else. And a month later, they found it.
So the problem with that scenario, the problem with it not falling on the prosecutor is that that would then incentivize the police to not turn over everything, knowing that that would be some sort of exception.
Can I just add a wrinkle to that? Let's say the prosecutor reaches out to the police, says, there should be a DIR in this case. You know, I'm asking you for the DIR, please give it to me. I have to disclose it. And the response is, there isn't one. And a certificate of compliance is filled out, and it has all the things that we were discussing about a duly diligent search for the material. But yet, it does turn up 10 days later, and the police have an excuse for why it wasn't disclosed the first time. Does the prosecutor at least have the benefit of being able to use the police excuse?
It depends on the excuse. If that could potentially be a special circumstance situation, although it would depend on the reasoning why there isn't a domestic incident report filed if it's a family offense that requires that.
Is there a perfect police requirement, even though there's not a perfect prosecutor requirement? Or does the police get the same requirement that they have to exercise due diligence and make a reasonable inquiry?
So the statute doesn't specify with regard to the police specifically. However, if the police are aware that these cases are getting dismissed on speedy trial grounds...
Well, I think that's not exactly the question I mean to ask. Are the police subject to a stricter or more stringent standard? In other words, even in the exercise of due diligence and having made a reasonable inquiry, they don't know that something is there and therefore don't turn it over to the prosecutor. Is the same standard applicable if that later turns up?
The standard of due diligence and reasonable inquiry?
Yes, as opposed to perfection, which is basically, I think, a strict liability standard.
So it would be somewhat context and case specific.
So would the requirement then be when it's challenged that the police come in and as part of whether there was appropriate due diligence, an assessment made as to the credibility as to what they did or didn't do? Would that be factored in as opposed to?
That certainly could be. A circumstance like if a police officer fails to complete their police report in a timely fashion because they're in the hospital and they literally cannot complete the report. That could fall under a special circumstance where, again, the certificate of compliance wouldn't necessarily be invalidated on that grounds. However, what the people cannot do is erroneously insist that the items don't exist when they've never conducted any due diligence or reasonable inquiries into determining whether they've existed, which is exactly what happened in this case.
And where, if anywhere, at what stage does prejudice to the defendant enter into it, if at all?
It does not enter it at all with regard to speedy trial. Prejudice is only relevant to the 24580 sanctions and discretionary dismissal under those grounds. So prejudice, as far as a speedy trial determination, does not come into effect at all. It's irrelevant.
Thank you.
Thank you.
Good afternoon. May it please the court. District Attorney Patrick Perfetti in and of the County of Cortland.
Counsel, why isn't your adversary's process a reasonable one?
For several reasons, Your Honor. First of all, though she espouses that perfect compliance isn't the requirement, essentially she is advocating for a strict standard liability.
In what way?
Well, I think it bears noting, and it is in the factual record of this case, that the objection that was raised by her was, quite frankly, an 11th hour objection. There's been much case law in the lower courts relative to this practice of laying in wait to bring these challenges on the eve of trial, as occurred in this case. In fact, the
Well, I
challenge.
mean, I think that this case is a little different because from the beginning, the defense attorney was asking for a DIR and a 911 tape on a domestic case.
And what is shown in the record in this case is that the prosecutor handling the case for my office was not just aware of this case, but was also aware that there was pending a violation of probation and 3 other criminal contempt cases, all involving the same victim, who was his mother. And I would assert, very much as Justice Halligan has assessed, that he very well may have conflated one of the cases with another relative to whether there was a walk-in complaint concerning this particular case.
Why isn't there a burden on that prosecutor to come in and explain that?
Well, should the court demand an explanation, I think.
Okay, I'll read to it. Why isn't there a burden on the court to ask for an explanation from the prosecutor?
Well, I think certainly the court can exercise that. The court certainly should be left with that level of discretion to make these inquiries. The court did make certain inquiries.
Does the record indicate whether the prosecutor in the first instance did anything to confirm?
I don't believe the record does
I
indicate.
didn't see anything. I just wanted to make
No,
sure.
I didn't see anything in that regard either, and obviously I don't need to
So are
inform
you
this
saying
court
that they're not required to?
say again.
Saying that the prosecution isn't required to confirm that there is compliance?
No, I'm not saying that at all. In fact, what is not reflected in the record is that there is a standing order from my office to all 7 of the law enforcement agencies in my county directing that they are to provide to my office the
So
case file.
is it because the court didn't make the inquiry so that the record could have been established? Is that the problem?
I wouldn't say necessarily that that's the problem. That
Here,
could be
in
that
this
definitely
case.
could be a problem in this case. And if it comes down to a fact-finding issue, I certainly don't need to advise this court of its limited judicial or jurisdiction relative to fact-finding. And perhaps that's something that this court decides needs to be done, is a further fact-finding in that regard. But in the
Don't take the record as it exists today and make a decision?
Well, I certainly like you to, and I think the decision ought to be that my
I guess,
agent acted very reasonably, and we were sanctioned.
but accepting what you
Appropriately.
said with respect to you're taking proactive measures to ensure that there is compliance, but you understand when appellate courts are reviewing, they need a record.
Absolutely.
And so that's the issue here. Is the record sufficient to support an affirmance?
I believe the record is sufficient, and had the record not been sufficient, I'm pretty certain, having practiced in front of Judge Campbell as long as I have, she would have felt quite free within her authority to ask
So
for
why-
additional facts.
Why is that the case? Where in the record do you find the support for an affirmance?
There are a couple of places. First of all, the disclosure ultimately was made,
Okay, but
and it was made prior to trial.
timely. So is it your view that if it's made at some point, but after there is a initial COC file that turns out to be incomplete, and the 30 clock, did the 30 clock not run because of the supplemental disclosure? How is that?
I would say
relevant?
that the 30 clock hasn't expired. The statute
because
itself does
why?
anticipate the filing of supplemental certificates of
Okay,
compliance.
so if I were to disagree with you that you can file a initial COC that is not valid because in fact, due diligence was not exercised. And I understand you're saying it was exercised here. That's what I want to understand more about.
Right.
But that a supplemental disclosure after the clock has run doesn't cure that problem. What I'm interested in understanding is on the facts here, why in your view was due diligence exercised, if that's your position?
Well, ultimately, when defense counsel in this case asserted the reason why the 911 recordings and the DIR, in their belief, were there, additional inquiries were made, they were discovered, and they were turned over the very next
That's
day.
after this initial COC.
Right.
Is there anything you can point to before that initial COC is
But
filed?
I think that question premises that the initial COC, because of those failings, then becomes invalidated or insufficient. There are many
Why
times.
doesn't it? I mean, why doesn't it? You're supposed to move forward with reasonable efforts of what you did before you announced ready in court. And there's nothing on this record to say, you know what? There's a standing order from my office to all the law enforcement entities that they should produce all discovery as soon as possible. I spoke to Sergeant X, Y, and Z who told me blah, blah, blah. I then called the first responding officer who said this. I called the 911 entity and dropped a subpoena to see, like, there's nothing on this record for us to establish what's reasonable and what's due diligence. And I think that's the point of 245.
Well, I would agree, Judge, that 245 sets out a reasonableness standard and a good faith standard, and I would assert that my agent did act in good faith. The initial materials
Don't you
were
have to have
turned over
both?
within a
Don't
day.
you have to meet both ends of that standard, that it's good faith and reasonable efforts?
Yes,
Right, and good faith doesn't seem to be an issue here. I don't hear anybody saying that you acted in bad faith.
Okay. And I would say that even if we say that's satisfied, that the, reasonable efforts were made in that the materials that we did have that were produced within a day of defense counsel assuming responsibility for the case. Many times we have those materials in advance of defense counsel
But
even
that
coming
seems
on
like
to
a
the case.
strange argument to say there's something obvious that was missing, but because we produced the rest of the stuff quickly, our efforts were reasonable.
Well, I think that has to factor into that. The reasonableness test would obviously look into a multitude of things, and I think the initial provision of discovery is a very significant factor. It allows defense counsel to make certainly the initial consultation with their client meaningful and allows them to decide how they're going to proceed.
Counsel, it sounds to me like that argument, and I agree with the chief, there's something off about that. That would maybe go more to good faith. In other words, since you can show that you reasonably turned over a number of things, even a lot of things, in a timely or early manner, that you're not acting in bad faith. But I don't understand how it says anything about the effort to locate the thing that wasn't disclosed.
Well, I mean, ultimately, the prosecutor did locate it and did turn it over. So in the end,
Well, I'm obviously talking about what happened prior to the filing of the certificate.
and to that, I would say he was mistaken.
But had the defense attorney never requested that material, according to your analysis, that would have never been turned over, because you would have relied on your assistant saying that there was no DIR, there was no 911 tape, and those existed. So-
Those did exist in
The defense attorney had never asked for it. Were you ready?
the prosecution was ready. Ultimately, in the end, those materials were not used by either party in the litigation of the matter.
Well, partly because you were precluded from using one of them.
Correct. And the defense didn't choose, or find it useful for them to utilize either. And that would be my point, is that we did suffer a sanction relative to that, a sanction that, quite frankly, I think was appropriate, and the intermediate appellate court as well felt was appropriate.
That's not what 245 allows for. When it comes to questions of readiness for speedy trial purposes under 30.30, I mean, regardless of this prejudice argument that I think you're making, the statute is very clear. You cannot deem that the prosecution statement is ready if they have not complied with 245 and their automatic discovery obligations. And 245 requires that the prosecutor have exercised due diligence, not reasonableness, due diligence, right, in identifying the material and turning it over.
If I may address that. The statute does require that. The statute also requires the reciprocal discovery, which never occurred in this case, to the admission of defense counsel herself. And I think as well, the court did address the issue of the, in fact, Your Honor addressed the issue of actual possession as opposed to constructive possession. The 911 tapes, those recordings are clearly not in the possession of a law enforcement agency. I think the case law is clear that emergency call centers are not law enforcement agencies. They are an enumerated discovery item, so I don't dispute that, and that they are appropriate to be turned over in that instance. However, it is very often the case where the people are deemed ready, where not everything even exists or is been turned over to the prosecutor itself. So in that regard,
I understand that, but it sounds to me like you're saying the prosecutor takes whatever they've got and they sit back and they say, that's what I have, that's it. And I don't know that the statute permits the prosecutor to do that. Now, in any particular case, even counsel concedes that it's for the judge to decide whether or not, under the circumstances of that case, the prosecutor's actions or inactions satisfied the requirements of the statute.
and I would assert that I think the record is clear that the trial judge did make inquiries and made inquiries of both parties.
But the inquiry was, what's your answer to this? And the answer was, it's not there, without any way of exploring or confirming that the prosecutor has done something that complies with the statute to ensure that it's true, it's not there.
And to that extent, I can't answer for something that's not in the record, Your Honor.
But the burden is on, strikes me, given this statute,
Right.
on the people to come forward with, right,
Well, I think there's
whatever they're going to present as their argument
I think
for how
there's
they are in compliance.
I think there's also a duty on the court to make the appropriate and relevant inquiry, which the inquiry
And
that
if they
was made
fail
was
to
made.
do, and if they fail to do that, who bears the burden or who has to deal with the consequences of that?
Well, I think it's within this court's authority to remand the matter for the further inquiry there by the court.
But isn't the point to conduct that inquiry in the moment so that it can be addressed then as opposed to down the road when, enough time has elapsed that if your initial certificate is invalidated and a supplemental certificate doesn't cure it, your clock is run?
I would agree. Ideally, it should be done in the moment. However, I think, as we all concede, this is a case of first impression on this particular issue by this court. Thank you.
Just to address a few points made by my adversary. In this case, there was no 11th hour objection or laying in wait. The items of discovery that were missing were brought to both the court and the people's attention at the very first court appearance after the certificate of compliance was filed. That was within the speedy trial timeframe. Speedy trial had not even elapsed at that time. The people still did nothing to try and obtain those items. And as far as when the speedy trial motion was made, that was made the day after receiving the police report and the domestic incident report. So there was no laying in wait in this case. With regards to a standing order to the police regarding items that need to be disclosed to the people, I would argue that a standing order is not good enough. The order should be made on each case. The police should be receiving that order that on this particular case with these arresting officers, everything from this case needs to be turned over to this office.
Would that have been enough here?
Potentially, we don't know because we don't have enough information about when the people received the police report, the domestic incident report from the police. Good faith alone is not sufficient as far as a standard goes for a proper certificate of compliance or the people's discovery obligations. And again, 24551A, which was amended in 2022, specifically includes due diligence, good faith and due diligence as being the standard in assessing the propriety of a certificate of compliance.
And with respect to the remedy crafted by the court here,
So it wasn't really a remedy because the people didn't voice any intention to introduce the 911 call into evidence. So, and that wasn't the relief requested. The relief requested in this case was dismissal on speedy trial grounds. Sanctions were never requested. And the court erred in assessing sanctions.
does the statute provide short of dismissal if the time is run out?
I'm sorry?
Does the statute allow for the court to have done what it did if the people had asked for it?
So if the speedy trial time.
Or, I'm sorry, if the defense, if they does what was done here, is that something that was provided for when the statute was amended to take 3030 and the discovery statute and join them together?
So if the speedy trial time had not elapsed, then certainly a sanction would have been appropriate. But because the speedy trial time in this case had already elapsed, it should have been dismissed on those grounds.
So once it expires, you can't just say, well, preclusion is enough.
Right.
I'd like to
Regarding,
push back on you a little bit on the standing order, because doesn't that really depend on the characteristics of the individual office, DA's office, vis-a-vis their law enforcement entities, right? Because I could envision a very large district attorney's office that has a standing order with 30 law enforcement entities that they deal with routinely, and there's a front office, an intake bureau, a case assessment bureau that regularly looks at those standing orders, looks at the discovery as it comes in, calls police departments to do a checklist, and sometimes the ADAs don't get that information until, a week or two later. And then at that point, they make an assessment of what they have and what they're missing before they file their certificate of readiness. So there could be circumstances where a standing order is entirely appropriate, but the point is we need a record to actually establish what was done and how the discovery was collected. I mean, I don't think that the order itself is the issue, do you?
that's right. And no, it's not the issue. I would just say with regards to a standing order versus a specific order on each case could contribute to due diligence or could be an argument that the people have exercised due diligence if they can show that they've made that specific order on a specific case. With regard to the belated discovery and curing an improper certificate of compliance, that belated disclosure of discovery does not cure an improper certificate of compliance that was filed from the outset without due diligence or reasonable inquiries. There must be some demonstration of the due diligence and reasonable inquiries exercised from the outset, particularly because the people's continuing duty to disclose pertains to items of discovery that were not supposed to be, not previously known to the disclosing party. Despite the fact that the people were notified multiple times about the missing discovery in this case, they repeatedly, erroneously insisted that it didn't exist, and the belated revelation that it does exist is not akin to learning of new discovery, for which a supplemental certificate of compliance would be appropriate. Additionally, because the items of discovery in this case were in the possession of the police, they are deemed to be in the possession of the people. If I could, I see my time's up, if I could just make one more.
Of course.
Thank you. I just want to speak very briefly about the no adverse consequence language in 245.50 sub 1 and sub 2. This 245 was intentionally connected to the speedy trial statute to incentivize compliance or risk the repercussion of the people's case being dismissed. There's been some argument that the no adverse consequence language means that a speedy trial dismissal cannot occur or that an illusory statement of readiness cannot occur. That's not the case. No adverse consequences, and we know that's not the case because that language is present in both 245.50 sub 1, which pertains to the People's Certificate of Compliance, and 245.50 sub 2, which pertains to the defense's Certificate of Compliance. And because speedy trial is not, dismissal of the case on speedy trial grounds would not be an adverse consequence that could pertain to the defense, that would give different meanings for the same thing within the same statute.
Let me ask you this. Do we have to even consider that if 245.50, paragraph 3, which is specific to speedy trial and talks about trial readiness, begins with notwithstanding the provisions of any other law?
Right. So you're exactly right, Judge, that no, you wouldn't need to. And in fact, if no adverse consequence meant speedy trial, you would think that that would be included in that section, which is specifically called trial readiness. The no adverse consequence pertains to personal sanctions against individual litigants, as 245 has the forced effect of a court order. For the foregoing reasons and the reasons, thank you, Judge.
Thank you.